KZSU-FM Stanford, welcome to another edition of Hearsay Culture on the Hearsay Culture Network. My name is Dave Levine. I'm a professor at Elon University School of Law, as well as an affiliate scholar at the Center for Internet and Society at Stanford Law School. Today, we have an exceptionally timely guest in light of the state of our world. The New York Times' Adam Liptak, who covers the Supreme Court, has been covering it for a few decades, and also writes a column called Sidebar for the New York Times. Many of my listeners are familiar with Adam and Adam's work, and today's discussion is going to run the range. Obviously, we're going to be talking about the state of judiciary in the Supreme Court, but also, as we were recording on April 27, 2023, we do have to talk about the sudden foisting of generative artificial intelligence, or AI, onto our society, particularly how it might impact and has already impacted the judiciary. There's been some stories, including one a couple of days ago reported by Politico, involving Justice Gorsuch and a real estate transaction that was disclosed sort of by the justice in his financial disclosures. We'll talk about those things. And then more broadly, I want to dive into the state of judiciary generally. Adam is a graduate of Yale Law School, practiced for 14 years before joining the New York Times in 2002, was a finalist for the 2009 Pulitzer Prize for explanatory reporting, and has been teaching at his alma mater on occasion, as well as the University of Chicago. We are recording via Zoom as we do, and I want to thank Adam for joining us today on the show.
Really great to be with you, Dave.
So Adam, let's start off at the top level here, right? The judiciary is always in the news, but over the last 6 months, year, we've seen some big stories that have come out, right? We had the leak of the Dodge draft involving abortion rights. We've had continual reporting about Justice Thomas and he and his wife's interactions with the political process. And then most recently, and this is just a couple of days ago, again, recording on April 27th, a law firm, Greenberg Traurig, and one of its senior partners bought Gorsuch-owned property that was disclosed to some degree by Justice Gorsuch, but as the reporting indicates, and you might be able to shed more light on this, the name of the entity acquiring the property was not. All of these are really big stories and not the kinds of stories we typically are focusing on with the Supreme Court. So I'm curious, writ large, if you can help us understand the context and what's going on here on the Supreme Court itself.
So there are two things going on, and they may or may not be related. The first thing that's going on is that I've covered the court for 15 years, and for almost all of my time there, it was a 5-4 court. It was a court which basically leaned right, but not always. And the swing justice for most of those years, Anthony Kennedy, and then briefly Chief Justice Roberts, would sometimes find a coalition with the left and issue decisions in favor of things like gay rights and affirmative action and abortion. Now, with the appointment of 3 Trump justices, we have a lopsided majority, a 6-3 court, that is out of step with the American public on many issues. And as you said, Dave, the leak of and then the issuance of a decision overturning Roe v. Wade was a real shock to the system. And that caused the court's public approval ratings to drop. It gave a political windfall to Democrats because the decision turned out to be quite unpopular. So that's what's happening on, call it, the legal track. Mm-hmm. At the same time, the court is under renewed scrutiny for not only its formal activities, but for ways in which the justices have exposed themselves to at least what some people would say is an appearance of impropriety. And you listed, some of the highlights. the fact that Justice Clarence Thomas sat on cases arising out of January 6th, even as his wife Ginny had taken steps to urge officials to overturn the election, troubled a lot of people. And then there were a series of, then the Times had some reporting that there was good evidence that Justice Alito had given a heads up to a party in a case involving contraception called Hobby Lobby before that decision came out. And then we had ProPublica's couple of real blockbusters on enormous sums of money and lavish trips. I shouldn't say enormous sums of money spent on lavish trips by a big Republican donor named Harlan Crow, including super yachts and private jets and so on for Justice Thomas, who in other settings says he prefers to travel in an RV in Walmart parking lots.
Right.
Then another ProPublica report that Harlan Crow had purchased real estate from Justice Thomas. And then, as you say, just recently, another report that I think I may have the details slightly wrong, but I think 9 days after his confirmation, Justice Gorsuch, who'd been trying with some partners to sell a parcel of real estate in Colorado, managed to sell it to a top lawyer at the law firm of Greenberg Traurig, which occasionally appears before the court. Now, I should say that the lawyer in that case said he didn't know Justice Gorsuch was part of the consortium, has never met Justice Gorsuch, and I don't think we have any reason to doubt that. But what it does point out is that the disclosure requirements, even if they're scrupulously followed, as Justice Gorsuch may well have, or when they're not, as everyone, including Justice Thomas, seems to agree that Justice Thomas had not, those disclosure requirements may not be sufficient. And at a minimum, we might want to be thinking about more transparency on the court. But then the larger question is not should they be disclosed, but are the things being disclosed things that we're comfortable with?
Yeah, and that's kind of where I appreciate you raising that last point, Adam, because that's where I'd like to begin. You know, there are rules of ethics, and then there are ways that people who are judges should behave. And certainly as a law professor, there is following the law, and then there's best practice. Am I wrong to believe in 2023 that a best practice of a Supreme Court justice should be not just meeting the standards of disclosure, but really being scrupulous about what we used to call the appearance of impropriety?
Right. I wrote a column a couple days ago contrasting or comparing an incident 20 years ago when Justice Scalia went duck hunting with then Vice President Dick Cheney, who had a case before the court. And Scalia, you know, wrongly in the eyes of many, refused to recuse. But there was a passage, in his 21-page combative memorandum explaining his reasoning for not recusing, where he said, "I have been the subject of cruel jokes from late night comics." And I talked to a law professor at the time. He said, "You know what? Late night comics have a pretty good sense of the appearance of impropriety. If you're the butt of jokes from late night comics, maybe you should think twice about what you're doing." And to your point, Dave, not because the ethics code says that say X or Y or whether you, but really, if it stinks, why don't you stay on the other side of the line?
Right. And so, you know, which raises, you know, I guess the ultimate question that I want to dive into, which is what's going on. I mean, we know factually what's happening, but is this a reflection of society, Adam, in the sense that our standards are eroding or have eroded? The judiciary has, at least theoretically, been perceived, and I think to a fair amount, have also been very serious about maintaining a separation from the political process and political machinations. And it's hard to see that that's still happening.
Right. It's probably a little more confusing than that,
Mhm,
because back in the day, Felix Frankfurter would be hanging out with FDR all the time.
mhm.
And there are other examples of justices, Abe Fortas and LBJ, being close to one another in a way that's unimaginable today. So it's not a straight line in any particular direction. And Fortas, of course, had to resign over taking sums of money from a business executive. So there have been bumps along the way. But for a court that has all kinds of problems already in public perception of its legitimacy, you might think they'd try to walk a straight line, and you might think that in the face of calls for years now to have a more robust and binding and enforceable ethics code, they might have taken steps to do that. But in fact, just a couple of days ago, Chief Justice Roberts, in declining to appear before the Senate Judiciary Committee to talk about ethics, and that's a defensible decision. There's a separation of powers issue there. Uh, he sent along a note saying, here are the various kinds of ethics provisions that either bind us or that we follow voluntarily. And it was really a regurgitation of stuff he's been saying for more than a decade. And it didn't seem to satisfy people who think the court should get much more serious about some of these issues.
So we're chatting with Adam Liptak of the New York Times on Hearsay Culture and the Hearsay Culture Network on KZSU-FM Stanford. What does seriousness look like in this context? In other words, what does that appear beyond the judicial code of ethics?
Well, on the disclosure side, the disclosure requirements are quite weak. And we could have prompt disclosure, not disclosure that arrives about a year and a half after the fact. We could have detailed disclosure about how much justices are reimbursed for when they speak at law schools and bar events and so on. We could have more detailed disclosure about spousal activities and spousal income. And we could have, and gifts, and we could have justices, even if gifts are allowable, declining the gifts because it's as you suggest, Dave, it's the better practice.
Mm-hmm. And so we're not doing futurism and crystal ball gazing here on Hearsay Culture, but what are the prospects for that, in your opinion? Do you see the court, notwithstanding Justice Roberts declining to appear in front of Congress, which, as you say, is defensible? What are the prospects for the court taking this seriously in light of this real cavalcade of disturbing things happening on the court in the last 12 months?
I don't expect anything more from the court. I think it's possible, although this has turned into a partisan issue, sadly.
Right.
It's possible Congress acts. It's an open question, and I don't know that it's an easy question about whether Congress is entitled to tell a coordinate branch how to run its affairs. So this is a messy situation that is likely to remain messy.
It really is, Adam, a distressing scenario that we can't expect the court, or you don't expect the court to handle it, and you would know. Do you think that there are other ways that either politically or otherwise the court can be, and not just the court, the judiciary can be influenced in these regards? Because we have relied upon the judiciary and indeed the legal profession to be self-policing, and that seems to be failing.
Well, there are political responses.
Mm-hmm.
I'm not endorsing any of these.
Mm-hmm.
But of course, one political response is impeachment if we think a justice has really become corrupt. Another political response is increasing the size of the court. And that's something that could be done by act of Congress, doesn't require a constitutional amendment. A third response is a term limit or mandatory retirement age, which would bring us in line with the constitutional courts of every developed democracy. but, and this is contested, probably does require a constitutional amendment. Congress could influence the court's docket. The court, not a very hardworking court, has almost complete discretion over what cases it will hear. And Congress could make it work a little harder, could make its docket more mandatory as it used to be back in the day. And Congress then has an appropriations power. It does set the Supreme Court's budget. So there are things the court could do, but I mean, the Congress could do, but given the makeup of Congress, none of that is likely.
Mm-hmm. There have been also, and you mentioned impeachment, which is obviously exceptionally rare. There have been some reports of judges who have gone or are approaching senior status, who have at least anecdotally received some internal pressure to, if not go to senior status, if that hasn't happened. And for those that aren't familiar, senior status is a very common designation for a judge who is nearing retirement, or at least does not want to have a full docket. But there have also been situations, which is part of lifetime appointment, where judges have refused to leave the bench. And I'm curious if you see those and in which case then more forceful measures have at least been considered, if not used. Do you see that as a way somehow, and with notwithstanding the age issue, to kind of bring pressure to kind of even raise the suggestion of impeachment is itself, right, a bit of a nudge?
So we have examples, not entirely on the track you're talking about, of real efforts to encourage Ruth Bader Ginsburg to step down so that President Obama could have named her successor. She decided not to, and President Trump named her successor, which is why we find ourselves in this 6-3 court. We have Justice Breyer just last year stepping down, a little reluctantly, I think, but seeing that the political calculations were such that he ought to step down. You have the virtual certainty that justices like Thomas or Alito would never step down under a Democratic precedent. As an aside, this idea that justices should make political calculations about when to retire is also problematic and out of step with the rest of the developed world. And then there have been instances where a justice has really gone into cognitive decline, refused to step down, and the other justices made an informal pact among themselves that in a 5-4 case, they wouldn't let that justice have the deciding vote.
Mm-hmm. And these are all, again, largely self-policing, which is where we're left. There is one other aspect of this before I want to turn to another topic, which is the hearing process itself. For decades, the hearing process, when judges, and not just Supreme Court justices, but even district court judges at the federal level are nominated, that have been criticized for being theater, that it isn't really questioning, it isn't really deducing information. And this goes back, like I said, decades. It would seem that a role for Congress would be to reinvigorate the hearing process beyond the political theater. But as you say, it seems like that's as much of a fool's errand of sorts to expect that to happen as the kind of policing that at least I'm suggesting we'd like to see on the Supreme Court. Am I being too cynical?
Yeah, I have been in a minority for a long time, thinking that confirmation hearings actually add some value, that when you saw Roberts and Kagan and Alito and Sotomayor kind of thinking on their feet and making some distinctions and being willing to talk about some stuff, say the citation of foreign law or the scope of the right to privacy, you learn something, not a lot, but you learn something. One problem is the senators are not particularly good at asking questions. The larger problem is that the nominees are well coached not to answer. But for the longest time, I thought that they're better than nothing. Lately, though, the amount of partisan posturing really makes me think that the modern confirmation hearing has gone off the rails. and I'm receding from my view that they're better than nothing. Maybe they're worse than nothing.
Well, and I kind of shared your view on that as well, Adam, until the Kavanaugh hearing, where while at the same time, and I should disclose that I was one of the professors who signed the letter that your newspaper published, right, calling for Kavanaugh's nomination to be rescinded and for him not to be confirmed. And my basis for doing that was his behavior in front of the Senate, which I viewed as being way beyond the pale for someone sitting on the Supreme Court, as opposed to a substantive concern. In that sense, there is some merit to the hearing process, at least to the extent that the public was able to see and then judge whether this person should be on the bench. On the other hand, as you allude to, as far as the decision that the committee and ultimately Congress made, it obviously seemed to have no bearing. But in terms of a public perception perspective, is there still some value, notwithstanding our more or less mutual dubiousness about it, for at least the public to know something of what's happening?
Well, I think I agree with you that Justice Kavanaugh had a very bad day and displayed the opposite of judicial temperament in response to very serious allegations against him. And I think there's a value in that people should see whether a nominee has the kind of temperament we associate with a great justice on the Supreme Court. So that's something. And I suppose it's something that when Justice Ketanji Brown Jackson was asked some fairly outlandish questions, she kept her cool. That doesn't really go to the law. It goes a little bit to character and temperament. I suppose, again, maybe better than nothing.
Adam, let's turn to journalism a bit before we come to the third focus that I want to have for today, which is technology. Your beat is pretty unique in that you're covering the highest court in the land and arguably the greatest court today. For those that don't think about the beat itself and the job, describe for us your average day when the court is in session, in terms of how you're gathering information and how the modern media environment allows you to share it.
Yeah, so it's hard to answer that in a concise way.
You don't have to.
Let me put it to you this way: the great Supreme Court reporter Anthony Lewis years ago said the key to the beat is months of preparation to be ready for the morning they do something. So the court really takes action maybe 7 mornings a month, and they do 3 basic things. They decide to hear cases or not, they hear arguments in cases, and they issue decisions. And for all of those things, you want to be up to speed on the court's work, perhaps have pre-written some stuff. I mean, if they're going to grant a case, that's a 1-line order. They don't add anything to your knowledge except for the news that they're going to hear the case. And if you've pre-written 600 words on the basics of the case and you can add the Supreme Court announced on Monday that it would hear, then you're in pretty good shape. Argument stories are harder because you have to take account of where the court seems to be heading. And decision stories too, I mean, they can go in more than 2 directions, but there are 2 basic directions they're going to go in. And you can pre-write versions of some of that stuff. So the bread and butter is those 3 things. But then you also try to bring value to the reader who sometimes has a hard time chewing through the purely legal stuff by doing setup pieces, maybe visiting with the plaintiff in a case and bringing the human side of the case to life. In my column, I'll sometimes rely on law professors and social scientists for insights about themes at the court. And in general, you want to be approaching the court's work in as many ways as you can. And then additionally, layered on top of this now and fairly lately, there's been a lot of attention to the kinds of scandals we've been talking about. So there's more than enough to write about.
Of course, the famous moniker, all the news that's fit to print, right, applies to reporting facts and evidence. And I'm curious how you see, or do you see your role as providing even more, as you allude to, of that context and public understanding of not just this happened at this time, but here's how to understand it. Notwithstanding your column, or is the column where you try to do that work?
So I think a news report should be more than who won and who lost. It should be that, and it should also explore the coalitions on either side, and also the legal principles that will apply not only to the given case, but to many other cases. And once you're at that point, you're talking about consequences. So you want to play out not only, did company X win or lose, but what does this mean for patent law or class actions or whatever generally? And that requires some sense of context that's not going to be on the face of the opinion. And then also maybe backward looking to say, well, how does this fit in with what we understood to be the doctrine? And how has this maybe changed or warped that doctrine? So all of this is to say that it's not enough. Not that it's easy. I mean, you get a 100-page decision filled with legal jargon. You have to write really quickly. But it's not enough simply to talk about what's in the four corners of the decision. You want to place it in a context of where it came from, and then spin it forward to what it means.
When you're reporting on the court, how much of your reporting takes into account the broader perception of, unfortunately, of the press as being biased, particularly where you're writing on what are often heavy duty, if not political questions, social questions, where people believe that not only is the court balanced in one way or another, but that reporters are as well?
So I don't know how to respond to that except by trying to play it straight. I do think that legal reporting is in important senses easier to play it straight than, say, reporting on climate or reporting on politics, because there are going to be almost always two very good lawyers arguing each side of the case. And if you just present their arguments fairly, the reader can decide for herself who's right. And similarly, when the big decisions come down, there will be well-articulated arguments in the majority and the dissent. And again, if you present those fairly, it's not a kind of, I say this, I hesitate just a tiny bit, but it's not a kind of both sidesism where you give the lunatic a chance to talk and the other person a chance to talk and say you've done your job. With very few exceptions, there are legitimate arguments on both sides of most cases.
Well, that gets to exactly where I think the crux of these issues are that I want to ask you about. There's enormous discussion that obviously is well beyond the judiciary and reporting about judiciary, involving balanced reporting and objectivity, which a lot of people in communications, in media scholarship, say is basically a false promise, that objectivity, because we are human beings from the get-go, is really not the standard, that the standard instead should be accuracy from the press. Not objectivity, but accuracy. And I recognize that this is a bit of a theoretical question, but that's why we're here discussing these issues on hearsay culture. What is that a distinction with meaning to you, the distinction between being objective or to put it differently, being balanced versus being accurate?
So each of those terms has some work to do. Accuracy, of course, is fundamental. We should never write something that is inaccurate, but accuracy is not adequate. It also, and I don't think that balance and playing it straight and being fair are problems. I think they're virtues. Objectivity is, to the extent I even understand what it means, is unattainable by human beings. But the goal of a newspaper report on a branch of government is to give citizens the ability to make up their own minds based on a fair presentation of the information they need to govern themselves. And it's you can try to boil that down into a word, but I think we know it when we see it. And at the same time, although I don't think conceive of myself as someone who does advocacy journalism, I think it's perfectly conceivable to have someone say, here's what one side says, here's what the other side says. You can make up your own mind. But my own view is, side number one has it right for this reason. And I think that's a perfectly legitimate form of journalism, so long as the premise is fairly presented.
We're chatting with Adam Liptak of the New York Times on KZSU-FM Stanford and Hearsay Culture on the Hearsay Culture Network. For those of you that listen regularly, you know that Stanford University's KZSU is nonprofit and non-commercial. I encourage you to consider making a donation to KZSU by going to our website. Additionally, I'm excited to mention the launch in May of 2023 of the Hearsay Culture Network, and more about that can be found at hearsayculture.com. Adam, coming back to this concept, let me ask you a related question, which boils down to translation. We're talking about, and you are writing on Supreme Court opinions and Supreme Court cases, some of which are well known by the public, many of which are not, on often very complicated, because they are by definition constitutional law issues that all but constitutional law scholars and lawyers vested in the area may not understand. And here you are with the platform of the New York Times. How much of what you're doing, in addition to the facts, in addition to context, in addition to being balanced, is really fundamentally explaining this is what the court is and what it's doing, versus how much of that do you rely on the reader to figure out themselves?
So that's the core of the job. The core of the job is taking complex legal materials and on deadline, trying to turn it into accessible conversational English. So put aside all of the other stuff we've been talking about interpretation and context and consequences. Job one is to write in plain English what just happened. And as you suggest, Dave, that is hard. And you have to have a reader in mind. You have to assume the reader knows something. And my own, sort of target audience in my head is an educated person, not a lawyer, but probably a college graduate, who is following the court and public events lightly, but doesn't know what habeas corpus or summary judgment means. And over time, and I've been doing this for a pretty long time, you come to rely on, colloquial English phrases that adequately and accurately capture the legal jargon in a way that both explains to the not particularly well-educated reader, but doesn't insult the person with some background in the thing. And that's hard, and you don't always succeed, because some things are irreducibly complex. I don't know if it's true, but Albert Einstein was said to have said, make everything as simple as possible, but no simpler. And sometimes the editor will want to make it even simpler than it can be. And my response has to be, that's great. If that were the case, I would love to write that, but it's not accurate. Goes back to the point you made in the beginning. I mean, accuracy is really the core of the thing. It's necessary, not sufficient, but it's certainly necessary.
Well, you alluded to editors, and I want to ask you about that as well, because I don't think there's a writer, much less a journalist, who can't point to a phenomenal editor that made their work incredibly improved. I will say publicly that I wrote several pieces for Slate and their future tense, and Tori Bosch was my editor there, who's moved on to Stat, and without question, she made my words so much better and understandable. I'm still blown away. So I'm curious, for someone with your experience, you just mentioned kind of a pushback with editors. And so if you could talk about that a little bit more, and the role of editors in the modern news system where you're fighting for attention and you're also fighting for people to continue reading?
So I think the main role of the editor, particularly with a beat like mine, is to be a proxy for the reader, to try to be that person we were talking about a second ago, who knows some stuff but not all stuff, and to push back and say, you know what, Liptak, you may think this is accessible, but it's not. You got to break it down. You got to explain what's really going on here. And so that iterative process with editors is really valuable. I don't always welcome actual additions to my prose for the reason we've been talking about, because it's very easy to get stuff wrong, and that can sometimes be a real discussion. As to fighting for attention and so on, I've not my problem. People read me or don't. I think it's a good place to come if you're interested in the Supreme Court. The New York Times is a decent place to get your news from. But if you're not, God bless you.
Mm-hmm.
If you want to read, politically tinged versions of it, that's fine. Not my thing, but good for you.
And so that's kind of, and you allude to it right directly. I mean, it's still, I'm sure it's mildly, if not more humorous to listeners for me to ask a question of a senior New York Times reporter about how to get attention. But of course, for most journalists today, across the board, it is a fight. And I'm going to put aside the economics, although that's related to it, because that's a whole separate show. But what do you say to reporters, to journalists who are coming up in the space, in this environment where you're competing most directly with TikTok, right, which has its own political controversies, but a congressman here in North Carolina, where I'm recording from, Jeff Jackson, who's new to the Congress, is already making a name for himself through TikTok videos. And reporters are on the same platform. The journalist that comes up today, right, versus a journalist that comes up in the 80s and 90s, really is in a different environment. What do you tell them about that need for attention? Because frankly, they can't be, and I mean, use the word aloof in a very strong way, but I don't mean to suggest you are, but they have to pay attention to. And so what do?
I hold out hope that if you write fresh, distinctive, insightful journalism, the readership will come. Maybe I'm naive.
Mm-hmm. Is that conceivably done in light of the media environment where everyone, at least all media entities that I'm aware of, are competing on the internet, for starters, for eyeballs?
So two kinds of answers. One is I'm the wrong guy to ask.
Fair enough.
I don't think I've ever been on TikTok. I don't watch cable news. In profound ways, I'm naive about the media environment. Mm-hmm. Second, though, is that the Times has a very sophisticated audience enterprise part of the business, and they figure out how we should reach our readers. And I don't think we do that by altering the content of what we write. The content of what we write should be classic New York Times quality stuff. But getting it out to the public, I'm happy to say the people in charge of that do a good job.
So and this will be my last question on it, because you alluded to it. In an ideal world, I think I hear you saying the reporter is doing his, her, or their job, and the marketing people are doing theirs.
I think that in short, right. Okay. I mean, you want to write attractive articles. I mean, you want to write articles where someone reads the first sentence and goes, I think I'll keep reading. This is interesting, rather than I have no idea what this guy's talking about. So you do have an obligation to meet the reader where the reader is. I'm not suggesting that. But as for, competing with all kinds of other social media and so on, we do journalism, and the people will come where they want.
Right. We're chatting with Adam Liptak of the New York Times on KZSU-FM Stanford and Hearsay Culture on the Hearsay Culture Network. Adam, for the last 15 or so minutes we have, I do want to turn to technology. You and I chatted at Elon University in February. Since then, it's amazing how technology has advanced. And of course, I'm talking primarily about generative AI and artificial intelligence. Before I get to that, I want to ask you a big picture question. We've seen, again, technology is impacting everything. Over the last 20 years, we've seen some very significant developments. I was practicing law in 2004, 2005, when PACER, or the online filing of documents, was becoming very common. And again, for those that aren't lawyers, as opposed to bringing a paper to a court, instead go online and do it. Now, of course, it's very common. In fact, in many courts, it's required. But then following that, we saw the explosion of online discovery. What is that, right? Emails and texts and so forth being part of the information that parties share. And at the same time, despite all of these advances, it was really only until COVID that we saw, and this is what I want to get to, cameras, right, and phones and other ways for people to access not just the court, but actual hearings, trials, and so forth. And so COVID, of course, blew the lid off of any notion that we could stay in a in-person world. So my first question for you as far as technology is what you see as the impact of video and virtual meetings and interactions between lawyers and judges on the judiciary.
Couple of responses. One is that the Supreme Court hasn't gone that far. The Supreme Court has live audio, which is a radical step for them and would have been inconceivable except for the pandemic. But it's a long way from that to video.
Right.
A second thought is that this really is a boon for litigants, because the cost of sending a lawyer maybe to a different state for a scheduling conference before a judge that could as easily take place on Zoom is a real boon to making litigation more efficient. But there are questions, excuse me, there are questions about whether video testimony violates the confrontation clause, and the court has a petition seeking review on that question. And I think there are hard questions about whether, say, a criminal defendant shouldn't be able to look someone in the eye, and whether a jury shouldn't be able to evaluate their entire body language. So there are ways in which it's possible to go too far in an area where basically the progress has been good.
To people who aren't familiar, they may hear that it was cataclysmic to just have audio in the Supreme Court as being, mildly surprising. Can you describe that in a little more detail? What makes that cataclysmic to the court and to the justices?
They are terrified, or were terrified, that people would make fun of them. And they do, sometimes misspeak and sometimes use kind of wild hypotheticals. And for the longest time, they would release audio at the end of the week on Friday, just late enough so that it's no longer newsworthy. And so to go to live audio, they were a little nervous about it. It turns out that, it doesn't let the Jon Stewarts of the world do very much with audio. I think they're scared of video, though. And they're also, and maybe there's some justification to this, they like their privacy. There are some security reasons why their images shouldn't be plastered all over the internet and the television. And maybe the largest reason is that they are small c conservative. They're wary of change, not for political reasons, but because they figure the way we've always been doing it is the right way to do it.
It's interesting. Your answers suggest the humanity of the judges. And of course, the law professor in me was thinking, well, there's a good reason, which is the debate and decision-making process might be better. You alluded to a little bit, right? If there's more privacy, even though it's a public court. How much of that is in play, right? The tradition of we need this special place that doesn't have the sunlight on it, right? The way we would expect in any other court, more or less. So
they deserve privacy for their internal deliberations. I get that. But once it's a public hearing, and once, 400 people can come in person, there's no reason why citizens in a democracy shouldn't be able to see their government at work. some of the justices will surprise you. They usually at their confirmation hearings say they're pro-camera, and then they turn up at the court and say they're anti-camera. And I remember Justice Sotomayor in particular making a point that was both correct and paternalistic. She said, well, if the public, sees an argument, they're not going to be able to understand what's going on. They haven't read the briefs. It's full of legal language, and that's all true. But let the public decide. If they're not interested in watching, they don't have to watch.
Mm-hmm. So turning to video, and just to be clear about it, first of all, there's no prospect of that happening that you see on the Supreme Court anytime soon. Yeah, okay. None. All right. So that being the case, you can envision that people will be pushing for that, if not right in the court itself, but certainly to the extent that there are interactions with staff. And I'm curious if you have noticed a willingness amongst the staff, to the extent that they talk to you, right, to push the court in that direction, or are they following right the justices in terms of how they view these things?
Yeah, the only voices that count are the voices of the justices, and the clerks and the permanent staff exist to help the justices. So if the justices aren't interested in cameras, nobody's interested in cameras.
So let's turn, before we get to generative AI, to one other development, which is the involvement of technology more broadly on how the court operates, right? And this is something we talked about at. But clearly, and I'm going back to the leak of the Dodds opinion, right? That leak, which itself was cataclysmic, was also instantaneously shared, as everything is on the internet. And once it was out there, of course, there's no way getting it back. The court's reaction to the leak was to lead this internal investigation that, at least publicly, led to no result. And I'm assuming that you, Adam, have no other information as far as what the result was, but I know that you have some ideas. And I'm curious if you could share your take on not only what the investigation of the leak told us about the court, but also about just what happened there.
So the investigation, a lot of people think, wasn't as rigorous and vigorous as it should have been. It wasn't terrible. It certainly terrorized the law clerks, and it's hard to do a leak investigation. When the NSA does a leak investigation, it often fails. So you can criticize the court for not trying hard enough. Fair enough. I don't know anything more about who leaked, and I think there are two competing theories, and both of them make a lot of sense. One of them would be that the leak came from the right, because there seemed to be 5 votes to overturn Roe v. Wade, but the Chief Justice was trying to pick off one of those votes. And if you get the draft out there, it might tend to lock in the 5 votes you need. Certainly, the 5 votes hung on, and the ultimate decision was, majority opinion was almost identical to the leak. The other side would be that the Dobbs decision was great for Democrats and led to a lot of outrage and led to great successes in midterm elections and elsewhere. And if you can get a couple months jump on that, maybe there's a strategic reason for the leak to come from the left.
Let's turn in our last about 5 minutes or so, and this is a topic for an entire other show as well, which is generative artificial intelligence, which has come to the fore really as a result of OpenAI's foisting of ChatGPT into the world in late November of last year. It's already been shown that ChatGPT appears to at least be able to write a first draft of a motion paper or even a complaint. It also appears to do, if not perfect, certainly very good legal analysis, so long as it is fed rules. It may not get the fine points, although it often gets those, but it certainly can give you an answer on top of all the other things that we've seen. right off the bat, I've got to ask you this question, which ties to the beat, which is how you see the court reacting, or do you see the court reacting to the use of ChatGPT or generative artificial intelligence in filings before the Supreme Court, which probably hasn't happened yet, but certainly, or maybe it has, or certainly is being used in the background.
I don't know why the court should care so long, and maybe this will be the theme of our little discussion.
Yeah.
So long as it's accurate.
Okay. Yeah.
You know? And what I've seen is in line with your comments, Dave. It's astoundingly good and smooth and plausible and often better written than something some lawyers might do. But there are some glaring weaknesses in it. I asked it to tell me something about myself, give me Adam Liptak's biography. And it turned out I clerked for Judge Guido Calabresi, which was flattering but false.
Yeah, right.
To spin your question just a little bit, because everything is most interesting about oneself. I don't think we're very far from giving the AI a Supreme Court opinion and say, write this up as a newspaper article. And it'll probably be pretty good. It might be missing, at first at least, the kind of context and consequences we were talking about. But the bare bones, it probably will do a pretty good job translating 100 pages of legal document into 1,000 words of newspaper story. So, my time is limited here.
Well, I mean, that's really the, the ultimate question. And I guess, we are still two human beings, as far as I know. I am not, incidentally, I'm not doing the key thing of using ChatGPT to write questions for me, by the way. But I am curious, what you're taking. This is a very opinion normative question, which is that what we want? I mean, and I'll ask you, Adam, I mean, as a personal question, right? Is that what you want? As someone who's watched the court for 20 odd years, do you want that role of technology, not just in the court, as you allude to, but also in journalism?
Yeah, the answer is a strong no. I don't want, but I don't know that it matters. It's coming.
So let's turn to the practical point. You're forcing me to stay very practical in these questions. I could push back, I guess, as a journalist, but you're right. Let's talk about the practical consequences. So step 2 of this would be, as you allude to, the use by the court of ChatGPT. Now, you've described a court that is reticent to use technologies like video for some good reasons and some more questionable reasons. But I'm curious, do you see ChatGPT more or less being a requirement because the clerks are going to use it? Do you see the court rejecting its use because we don't do that on the Supreme Court? Do you have any sense of what a Justice Sotomayor or a Justice Alito would say about the use of ChatGPT by the court itself?
I think almost every aspect of society will move faster than the court in embracing technologies like that. It's just, I mean, we've talked about this in other contexts. They're slow moving, and they also have the benefit, each justice, of 4 brainiac law clerks. So they have the horsepower to begin with. They don't need to outsource. Whereas, all kinds of other sectors of the economy will cheerfully outsource and take advantage of this technology. The court doesn't have that economic need, at least.
Do you see the court, and I'm afraid of the answer, but do you see the court as taking a lead, if not on the law itself, but in practice on understanding how we use this technology? I fear the answer is no, but let me be a little more specific. We're in dire need of guidance as a society on what to do with this technology, which of course is a topic way beyond what we're talking about here. But I am curious whether the court, with the authority, although it may be eroding, of the Supreme Court, could, if it had the inclination to do it, show leadership in this area, at least to the extent that these issues come before the court, but also in terms of their practices. Or is that just not their job?
Several responses. They're not very good at technology. And as you say, this has to arise in the context of an actual case. And those are just starting, if they are. And then the third answer is, and this came out the argument over the liability shield known as Section 230 of the Communications Decency Act. You know who really should be taking the lead on this? Congress.
Right.
These are policy questions. They're not constitutional questions. They're not statutory questions because we don't have statutes yet. So the court may, at some point, years from now, take a leading role, but other things have to happen. Cases need to ripen, and Congress should act. It's easy to say Congress should act, but Congress should act.
Yeah, and yes, and I hate to end on that note, but yes, this does seem to be the role of Congress and state legislatures, but it remains to be seen what they do. Adam Liptak of the New York Times, thank you for joining me today on Hearsay Culture. Thank you for taking the time. I do appreciate it, and I look forward to further discussions.
Thank you for having me, Dave.